Yes, sir. A very good evening to everyone. I, Nishant Anshul, a fourth-year student of USLLS, take this privilege to warmly welcome all our esteemed guests and participants to the inaugural webinar of the International Economic Law and International Relations Cell on the topic Changing Paradigms of International Commercial Law in the New Global Order. Before we proceed, I would humbly request all the participants to keep themselves muted for the smooth conduct of the event. We will have a question-answer session at the end of the webinar. Till then, the audience can post their questions in the chat box. Also, we will be circulating a Google Form link for attendance and certificates at the start and at the end of the webinar. The University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University, Delhi, is delighted to announce the commencement of the International Economic Law and International Relations Cell. This cell has been established with the objective of promoting academic and scholarly discussions on the emerging areas of international economic law and international relations. The increasing interconnectedness of international phenomena due to the increasing significance of cross-border communications has rendered the practical and academic use of single-disciplined and methodologically incomplete studies obsolete. Therefore, this cell aims to combine the essential components of international relations, international law, and international business. I, on behalf of the student committee of the cell, express my sincere gratitude to our Honorable Vice Chancellor, Padma Shri, Professor Dr. Mahesh Verma Sir, our respected Dean, Professor Dr. A.P. Singh Sir, and faculty coordinators, Professor Anuj Vaksha Sir, Professor Rakesh Kumar Sir, and Dr. Zubair Ahmed Khan Sir, for their constant support and guidance under which this cell has taken the present form. To welcome is to show honor. To welcome is to establish the integrity. I now invite our respected Dean Sir, Professor Dr. A.P. Singh, to welcome our guest of honor, retired Professor Mr. Abhijit Das. Over to you, sir.
Thank you, Nishant. Very well introduced the USLLS and the objective of starting the international economic international economic law and international relations cell, University School of Law and Legal Studies. A very good evening to all colleagues present here. Respected Professor Abhijit Das, my learned faculty colleagues, and student friends. It's a very auspicious evening today when we are launching. I think this is probably the first program that is being launched on the platform of International Economic Law and International Relations Cell that we have established some time back. And the topic that we are talking about, changing paradigm of international commercial law in the new global order, is a challenging topic as I understand. And a person like Professor Abhijit Das, who has been Professor of International Trade, had been at the head of Center of WTO Studies, Indian Institute of Foreign Trade, had represented India in several multilateral and bilateral trade agreements, trade negotiations for over 2 decades, and represented India in several landmark trade dispute matters that he has negotiated on behalf of India. I take this opportunity to welcome Professor Abhijit Das and put on record my sincere gratitude and thanks for sparing this evening for our students. I will not take much of a time. I will not stand in between Professor Abhijit Das and the students. Thank you so much, sir, once again, and thanks all the students.
Thank you so much, Dean Sir. I would now like to enlighten the audience about a keynote speaker. Professor Abhijit Das is an expert in international trade and WTO issues. He belonged to the Indian Audit and Account Services of the 1988 batch and took voluntary retirement from the service in 2011. He has recently retired as the head of the Center for WTO Studies, Indian Institute of Foreign Trade, New Delhi. He has more than 2 decades of experience in international trade in various capacities, including 5 years in the Government of India. He has participated directly in many multilateral and bilateral trade negotiations, including the Doha Round at the WTO and OECD steel subsidy negotiations. He drafted more than 50 negotiating submissions of India to the WTO on different issues, including agreement on agriculture, subsidies agreement, anti-dumping agreement, fisheries subsidies, and dispute settlement understanding. He coordinated and finalized India's submissions in 6 WTO disputes, including landmark disputes such as EC bed linen, EC tariff preferences, US continued offset, popularly called as US Byrd Amendment, and US cut to length steel. The list of his achievements is indeed very long. He has jointly edited several popular books on WTO and international trade. His current research interests include agriculture, digital economy, global value chains, geographical indications, environment, and negotiating strategies. With this, I invite Sir to kindly address the gathering. Over to you, Sir.
Thank you, Nishant. Dr. A.P. Singh, Dean, University School of Law and Legal Studies, GGSIPU, Professor Anuj Vaksha, Dr. Rakesh Kumar, Dr. Zubair Ahmed Khan, faculty coordinators, other learned faculty members, Anshul Agarwal, student coordinator, my young friends, ladies and gentlemen, a very good evening to all of you. At the outset, let me heartily congratulate the entire team at the University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University, Delhi, for taking this invaluable initiative to establish the IEL&IR Center. This is certainly a wonderful and an extremely timely initiative, which would provide inspiration to the students and faculty to deepen their insights in areas of international economic law and international relations through a multidisciplinary approach. And also, and I am being a bit demanding over here, and also to provide some practical insights for trade negotiators. It is indeed an honor for me to be the keynote speaker at this inaugural event. Now, international trade and economic relations need to be viewed and examined on a comprehensive basis from multiple perspectives, including law, economics, and international relations. Having been closely associated with international trade negotiations for over 2 decades, I will not hesitate in candidly confessing that while our trade negotiators often had inputs and analysis from the perspectives of law and economics, on almost all occasions, there were hardly any inputs from the perspective of international relations. And when I say this for India, it would be almost correct to say that a similar situation might be prevailing in most of the other developing countries. There could be certain exceptions, of course, but they would really be rare exceptions. While it is true that some of the concepts of international relations that are relevant for international trade negotiations might at times appear to be a matter of common sense and intuition, there is no running away from the reality that trade negotiators can substantially enhance their effectiveness from the structured exposition and analysis that is provided by scholars in the arena of international relations. The short point is that trade negotiators have a lot to gain from lessons provided by IR-based research and IR scholars. It is from this perspective that I once again compliment the University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University, for its outstanding initiative. In my address, I will initially focus on some of the seemingly paradigmatic shifts in the arena of multilateral trading system as embodied initially in the General Agreement on Tariffs and Trade and subsequently the World Trade Organization. Next, I would discuss some of the underlying features of the multilateral trading system that appear to provide the thread of continuity in the changing paradigm of international economic laws. In this segment, I will also elaborate on the implications of having a common set of rules for all WTO members and how it might militate against the interests of India and most other developing countries. Finally, in the last part of my address, I intend to dwell on specific elements that can be drawn from international relations-based scholarship for improving the understanding of negotiating dynamics and for enhancing effectiveness at the negotiating table. So starting with some of the paradigm changes in international economic and commercial laws, what have been some of these changes from the perspective of international trade and investment? First, the coverage of issues has expanded significantly from trade in goods to encompass other aspects of economic activities. It includes now trade in services, intellectual property rights, investment. Attempts are also being made to expand it further to bring in other areas of economic activities. I would elaborate on this aspect subsequently. The second paradigmatic shift, the way I look at it, is that the rules of GATT and the WTO have increasingly shifted attention from border measures to measures that are behind the borders. Some of the WTO agreements, including the Agreement on Subsidies and Countervailing Measures, agreements related to sanitary and phytosanitary measures, popularly called the SPS Agreement, and the Agreement on Technical Barriers to Trade, are some illustrations of these shift from border measures to behind the border measures. One also needs to point out that the General Agreement on Trade and Services has a very focused attention on domestic regulations, a matter squarely behind the border. Increasingly, international trade agreements are providing rules on what governments can do and cannot do through their domestic regulatory measures. In other words, these rules provide guidance on the substantive content of certain aspects of domestic regulations. In parallel, we are also witnessing attempts at how governments can regulate, which is a bit different from the substantive content. This is sought to be introduced into trade agreements through the rubric of regulatory coherence, as well as good regulatory practices. In other words, initially what we saw was rules on substantive content of behind the border regulations. But now in recent years, we are also seeing not only rules on substantive content, but also how should the government regulate the process which should underlie the regulatory measures. Third, when viewed from the perspective of integrated versus fragmented rules, there again appears to be a paradigmatic shift in multilateral trade rules at GATT and WTO. When the GATT was established in the year 1948, a common set of rules applied to all its members who were actually called contracting parties. However, by the end of the Tokyo round of multilateral trade negotiations in 1979, the GATT became a fragmented system of rules. While the basic GATT legal text was applicable to all the contracting parties, some countries could opt to be governed by specialized codes in specific areas, such as subsidies, anti-dumping, government procurement, code on technical regulations, etc. Thus, a twin system of rules emerged at GATT. In respect of some contracting parties, the GATT rules were applicable, while in respect of a few other contracting parties, GATT rules plus the rules of what were called the plurilateral codes were applicable. No doubt, this created considerable complexities in determining what obligations were applicable in respect of which contracting party. Within no time, the contracting parties realized the problems inherent in such a system, and a serious attempt was made to overcome it during the Uruguay round of multilateral trade negotiations, which were held during 1986 to 1994. And the outcome of the Uruguay round of negotiations on this issue has been very clearly articulated in the following recital in the preamble to the Marrakesh Agreement. Marrakesh Agreement is the foundational agreement of the WTO. So one of the preambular recital of the Marrakesh Agreement, I quote, resolved, therefore, to develop an integrated, more viable and durable multilateral trading system. Now, those of you who might be further interested on this issue could peruse the findings of the WTO's appellate body in the Brazil desiccated coconut dispute, in which the appellate body very clearly interpreted this preambular language of the Marrakesh Agreement to imply that the intention of the WTO members was to move away from a fragmented system of trade laws which had prevailed on account of the plurilateral codes at the end of the Tokyo round to a more integrated system where a common set of rules would be applicable for all members. Now, this is what prevailed when the WTO started getting implemented in 1995. However, over the past 4 years, we are seeing a different phenomena emerging, a different trend emerging. Some WTO members have initiated negotiations on issues such as electronic commerce and digital trade, as well as investment facilitation. These negotiations do not have a mandate from the entire WTO membership. Thus, it is likely that the outcome of these negotiations might result in a slew of new plurilateral agreements. This is likely to take us back to the era of fragmented trade rules. The fourth paradigmatic shift which I identify relates to the fundamental basis of undertaking negotiations at GATT and WTO. GATT was founded on the principle of reciprocity in trade negotiations. In other words, I concede something, but I must get something in return. Now, this concept of reciprocity in trade negotiations is explicitly mentioned in the preamble of GATT, where it has been stated, and I quote, entering into reciprocal and mutually advantageous arrangements, quotes closed. However, given their stage of development, developing countries were in no position to grant reciprocal concessions to developed countries in trade negotiations. This significantly curtailed the participation of developing countries in multilateral trade negotiations during the initial years of GATT. On account of a hard struggle waged by the developing countries, eventually in 1965, Part 4 was added to GATT legal text, and one of the provisions in Part 4 provided the legal recognition of the principle of less than full reciprocity in trade negotiations. This is contained in Article 36(8) of GATT 1994. According to this provision, I quote, developed contracting parties do not expect reciprocity for commitments taken by them in trade negotiations to reduce or remove tariffs and other barriers to the trade of less developed contracting parties, quotes closed. Thus, developing countries were not expected to offer reciprocal commensurate concessions to those that they might receive at the negotiating table from the developed countries. And this has formed the basis of what is popularly called special and differential treatment for developing countries, wherein developing countries assume some obligations that might be less onerous than what is undertaken by the developed countries. They might get a longer transition period for implementing some of their obligations. Now, this is the situation that prevailed when the Uruguay round of negotiations were launched. However, during the Uruguay round of multilateral trade negotiations under GATT, the developed countries were largely successful in their attempt at creating a trading regime with one rule for all, thereby largely undoing the non-reciprocal treatment of developing countries. And why do I say that? Subject to a handful of exceptions, most of the obligations under the WTO now apply equally to the developed and developing country members. Further, with the objective perhaps of diluting the non-reciprocity principle, the Marrakesh Agreement establishing the WTO specifies in its preamble the desire of WTO members to enter into reciprocal and mutually advantageous arrangements. Thus, on the issue of reciprocity as well, we appear to have come a full circle. GATT started with reciprocity. Thereafter, we had an era of non-reciprocity, and now we seem to be going back to rules that emphasize reciprocity. The final paradigmatic shift that I identify in the multilateral trading system and its rules pertains to the mechanism for resolving disputes at GATT and WTO. This mechanism has undergone very significant and substantial shifts over the past 75 years. Initially, during the GATT era, trade friction was resolved mainly through diplomatic means. Further, the dispute resolution system was based on the principle of decision-making by consensus. This allowed the country complained against to block the dispute settlement system from moving ahead, or at times, even preventing the adoption of dispute reports. Overall, it would not be inaccurate to state that the GATT could not overcome the diplomatic origins of its dispute resolution mechanism. However, when the WTO was established, its dispute resolution mechanism was referred to as the jewel in the crown of multilateral trade rules. The WTO established a two-tier dispute resolution mechanism, the first tier being panel proceedings, and issues of law and legal interpretation developed by the panel could be appealed to a standing appellate body. This placed economic constitutionalism and the rule of law on a stronger footing than before. Automaticity was inherent in WTO's dispute settlement process, including the adoption of dispute reports, as no member could block any stage of the litigation process. This made the WTO law legally enforceable and addressed concerns about diplomacy and pragmatism trumping rule-based order as prevalent during the GATT era. However, the dispute settlement mechanism of the WTO, as some of you might be aware, has now been rendered dysfunctional by the United States. The US has refused to nominate new members to the appellate body, thereby an important tier of the dispute resolution mechanism no longer effectively exists. It's like saying that, well, we will have a system of lower courts, high court, Supreme Court might exist, and there are no judges in the Supreme Court. So now we are seeing a similar system at the WTO, whereby there is no multilaterally agreed mechanism in practice, in existence, for WTO members to seek enforcement of their rights and obligations. The US has also hinted its preference for a GATT-type approach to dispute resolution. Again, are we seeing a shift back to the GATT era in this arena as well? Only time will provide answers to this question. At this juncture, it would be relevant to emphasize that some of the paradigmatic shifts in the multilateral trading system appear to be taking us back to the GATT days. The question for all of us to ponder over is the following: is the future of multilateral trading system, at least in certain respects, what prevailed in the past? Is our past really the future on some of these issues? If yes, what could be the implications for a developing country like India? And here it is the IR scholars who could provide very important research on these questions. Now let me turn to some aspects that appear to provide continuity to the multilateral trading system. First and foremost, the multilateral trading system appears to have been molded in the interests of the developed countries. And why do I say that? When the GATT was established in 1948, its rules were relevant almost exclusively for merchandise trade, which is also commonly called trade in goods. However, over time, services-related economic activities such as banking, insurance, telecommunications, cinema, information technology-related activities acquired considerable salience in the developed countries, To illustrate, in 1980, services comprised 65% of GDP in France, 59% in the United States, and 58% in Japan. In contrast, the contribution of the services sectors was relatively lower in developing countries, 45% in Brazil, and slightly lower, 40% in India. This provided a huge commercial opportunity to service providers from the developed countries to penetrate the markets in developing countries and expand their economic operations. In order to achieve this objective, the developed countries had to put some fetters on the ability of developing countries to restrict imports of services and nurture their domestic service suppliers. However, at that point in time, there were no multilateral rules on trade and services. This triggered a demand from developed countries from 1982 onwards to initiate negotiations at the GATT on trade and services. Consequently, when the Uruguay Round was launched in 1986, it included the mandate for initiating negotiations on multilateral rules on services. Eventually, multilateral rules on services, commonly referred to as GATS, General Agreement on Trade and Services, became a part of the WTO, and developing countries lost considerable flexibility to implement policies for nurturing their domestic service sectors. The saga of multilateral negotiations on intellectual property rights is very similar to that of services negotiations. With economic activities based on high technology and innovation becoming more crucial for developed countries, a need was felt by them to negotiate binding rules on standards of protection of intellectual property rights. The obvious aim of the developed countries was twofold. First, to curtail competition that was emerging from some developing countries such as India in the pharmaceutical sector. And second, to ensure large profits for their firms involved in knowledge-based sectors such as pharmaceuticals, movies, etc. As developing countries such as Argentina, Brazil, Egypt, India, Indonesia, etc., lacked the ecosystem for creating innovation-based businesses, they really stood to gain very little from these negotiations. In fact, characterizing developing countries as being marginal players in creating intellectual property would actually be grossly overstating their role. In 1980s, they were almost non-existent in knowledge-based industries. This can be gleaned from the fact that in 1985, Argentina, Brazil, and India collectively accounted for less than 0.15% of cross-border global revenue receipts on account of use of their intellectual property by other countries. On the other hand, in the same year, developed countries, including United States, United Kingdom, Germany, France, Japan, etc., accounted for 99% of the global receipts. It is therefore not surprising that many developing countries strongly resisted the negotiations on standards of protecting intellectual property rights. Ultimately, they were unable to prevent the agreement on trade-related aspects of intellectual property rights, commonly called the TRIPS Agreement, from becoming a part of the WTO. Now, the Doha Round of multilateral trade negotiations continued the tradition of developed countries attempting to negotiate rules in new areas of their economic interest. When the Doha Round was launched in the year 2001, It envisages the possibility of negotiating rules on trade and investment, trade and competition, transparency in government procurement, and trade facilitation. Binding rules on these 4 issues, which are collectively called Singapore issues, would have very, very significantly enlarged the space of economic operators of developed countries to penetrate markets in developing countries. However, on account of very strong resistance from nearly 100 countries, effectively led by India, Brazil, and Argentina, only trade facilitation could survive at the negotiating table. For once the developed countries failed, at least temporarily, from using the multilateral trading system for promoting their economic and commercial interests. The trend in expanding the scope and coverage of rules at the WTO to support and reflect the changing sectors of economic strengths in developed countries is evident in developments at the WTO related to electronic commerce from 2017 onwards. Now, let me also turn to a second and fascinating aspect which provides continuity to the multilateral trading system and its rules, which is using human rights to justify new rules. In 1940s and 50s, neoliberal economists with roots in Vienna and belonging to what is now loosely labeled as the Geneva School of Neoliberals crafted a theory of human right of capital to move across borders in order to protect the right of investors in foreign countries. Thus, the right to leave a country along with being entitled to take one's belonging, in other words, right to emigrate, was used as a peg to argue for free movement of capital across borders. While these arguments were framed as a fight for sanctity of property rights, in reality, it was lobbying for the sanctity of capital mobility. Some of the important figures in this endeavor viewed investors' rights as a supplement to the Universal Declaration of Human Rights, and the contribution of some of these people who advocated using human rights to craft investment protection treaties is now very widely recognized. Now, the important point to note over here is that half a century later, when massive protests led to the collapse of the WTO ministerial meeting in Seattle in 1999, attempts were made once again to invoke the concept of human rights for justifying deeper trade liberalization by propagating the narrative of protecting the individual's right to trade and move capital across borders. In this context, the following views of Ernst Ulrich Petersmann, one of the leading scholars of international economic laws, is relevant, and I quote, "The traditional disregard in WTO law of human rights is becoming as outdated and persistent disregard in international human rights instruments for economic liberalization and freedom of trade as preconditions for individual welfare," quotes closed. Further, Ulrichmann envisaged the possibility for, and I quote him again, "another human rights revolution in favor of non-discriminatory open markets, global competition, and more effective human rights protection," quotes closed. The short point that I'm trying to make is that by invoking human right protection, scholars have been successful in promoting the commercial and economic interests of developed countries in diverse areas. Another important thread which provides continuity is implementation of international obligations through domestic courts. The WTO was an important step in fulfilling the aspiration for multi-level governance of international economic law. This concept really is best captured by a very important functionary of GATT called Jan Tumleer, who postulated a theory of adequate anchoring in domestic law of international agreements and policy rules established by economic diplomacy, quotes closed. Tumleer's vision implied that national courts and constitution could be used as instruments for protecting capital rights as contained in international economic laws. Thus, domestic courts would have a pivotal role in enforcing international law. This is evident in some of the agreements at the WTO, particularly in the TRIPS agreement, which provides for the IP right holder to seek enforcement of his private rights in a member's domestic courts. Further, foreign exporters and domestic importers can seek enforcement of rights available to them under WTO's anti-dumping agreement, as well as the agreement on subsidies and countervailing measures, through a process of domestic judicial review. We are likely to see this trend getting further entrenched through commitments in free trade agreements. Now, before I turn to linkages between international economic laws and international relations, it must be pointed out that the same set of rules being applicable to all WTO members with almost no or minimal special and differential treatment is likely to have a debilitating impact on economic prospects of developing countries. Let's not forget that countries of the world are at different stages of development, and the same common set of rules might really have different impacts on them. One assessment is that the rules at the WTO appear to be skewed in favor of countries that are better endowed with technology and with capital, and there appears to be an inherent tilt against countries that are better endowed with labor. Secondly, some of the rules at the WTO appear to be asymmetric. On the surface, on the face of it, the rules appear very objective without discriminating one country against another. But if we scratch the surface, go a bit deeper, particularly in the agreement on agriculture, it's very clear that the benefit of the rules really go to the developed countries. Why I'm giving these illustrations is to drive home the point that the same set of rules can have very contrasting impacts on different WTO members, and hence to argue for a common set of rules being equally applicable to all WTO members really might not be in the interest of a country like India. Let me now turn very briefly to a few specific illustrations of concepts from international relations and theories which can be of interest to trade negotiators. These could include forum shifting, narrative building, forming coalitions, etc. Starting with forum shifting, one of the important questions, particularly in the context of state-to-state negotiations, is where to negotiate. While this might appear to be a bit of a procedural issue, in many cases, the issue of the negotiating forum gets intensely contested by different parties. Choice of negotiating forum determines the parties with whom to negotiate, the negotiating leverage available to parties to get foot draggers onto the negotiating table, whether the rules to be negotiated would be binding or non-binding in nature, whether the rules would be enforceable merely through peer pressure, diplomatic means, or through a law-based mechanism. There is considerable literature in the arena of international relations that can provide very valuable lessons to trade negotiators. Turning to the second aspect of role of narratives in ensuring negotiating success, the relevance and role of crafting a narrative for ensuring success at the negotiating table is definitely very crucial, but unfortunately often overlooked and not fully understood by developing country negotiators. How issues are framed can have a profound influence on the negotiating approach of political leaders and high-level functionaries who may neither have the time nor the technical expertise to understand the nitty-gritties of complex issues at the negotiating table. Often, it is not the reality at the negotiating table, but the dominant narrative around issues which becomes the filter for perceiving developments on various issues and their likely implications for countries. Allow me to provide two examples. During the Uruguay round, corporate entities based mainly in United States, European Union, and Japan, spanning many industry segments, pharmaceuticals, agrochemicals, computers, movies, and entertainment, aggressively pushed for stringent standards of protection of their intellectual property rights. What they wanted to achieve really was a monopoly-like grip on markets for continuing to reap windfall profits. However, they disguise their commercial interests as a moral endeavor to prevent theft of intellectual property. Through this clever crafting of narrative, they largely secured their negotiating objectives. The second illustration, which I would like to very briefly discuss, is the development narrative around the Doha Round. In 2001, a very concerted attempt was made by the developed countries to start a very comprehensive round of multilateral trade negotiations. And in order to bring developing countries to the negotiating table, this multilateral trade negotiations round was popularly framed, and a narrative was created that this is a round for development, a round for developing countries. And there was an inherent development promise in the mandate of the Doha Round. This is how the interests of the developed countries was framed, and developing countries agreed to launch of the Doha Round, believing the development promise contained in it. But no sooner had the trade negotiators abandoned the Arabian Seas and arrived at the shores of Lake Geneva, the development promise inherent in the Doha Round was very quickly abandoned, and hardcore commercial interests and economic interests overtook developments at the negotiating table. The short point which I'm making here again is the fact that how issues are framed becomes an important way of perceiving the issue by trade negotiators. Now, the third good illustration from the arena of international relations and applicable to trade negotiations is about forming coalitions. Many episodes of multilateral trade negotiations suggest that an effective strategy for developing countries to overcome power asymmetry at the negotiating table is to form coalitions with other countries having similar interests. Coalitions help in enhancing the heft of its constituents by countries sharing the load of technical analysis, pooling resources for common research, and reducing the possibility of individual countries being targeted by developed countries for taking positions opposing their interests. Now, considerable research in IR exists, which can provide very, very useful, helpful pointers on how to create and sustain a coalition. Now, these are the broad themes which I guess and which I also hope that the newly constituted cell in the University School of Law and Legal Studies, Guru Gobind Singh IP University, will pursue. Before I conclude, let me compliment once again the University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University, Delhi, for establishing the IEL&IR Center. My best wishes for its success. I will very keenly look forward to its activities, particularly multidisciplinary research and outputs that might have practical significance for deepening the understanding of international economic laws and trade negotiations for trade negotiators. With that, I conclude my address. Thank you, ladies and gentlemen, for having given me this opportunity to share some of my thoughts on this important occasion, and also for giving me a very patient hearing and for your kind attention. I would be very happy to address questions which some of you might have. So thank you once again, ladies and gentlemen.
Thank you so much, sir, for gracing us with your insightful expert comments. Now we shall take up questions from the participants. If there are questions, the participants can write the same in the chat box.
Yes, sir. Professor Anu, sir. You can unmute yourself, sir.
Right. Okay.
Sir, I think you are not audible, sir. Nishant?
Am I audible now?
Yes, sir.
Yes,
Yes, sir.
sir.
Yes,
Yes,
sir.
sir.
Okay. So thank you so much, Professor Abhijit Dasji. It was an extremely, say, enriching and I would say awakening lecture for all of us, the students at University School of Law and Legal Studies, and we, the teachers at University School of Law and Legal Studies. As our name suggests, we are committed to the legal studies, nonetheless giving the kind of interactions or interrelations across the disciplines that we have. We thought to bring about or create a platform where all important international economic law, international issues can be discussed and we can share certain kinds of thought. And to this end, the kind of encouraging words that you have told us and say inspired us to, we look forward that we would be working much more in this area. Again, on behalf of University School of Law and Legal Studies, I will request that at any stage, if we can allow some of our students to say meet you, interact with you, work on any kind of project, maybe once in couple of hours in a month or something, more to know the discipline and understand the subject. The students who are associated with this cell, that would be extremely, extremely good for our students. As we said, we have our LLB students. They are not specialized in these areas. Nonetheless, if this platform that we have just created, and today was inaugural lecture for this platform, we will look forward that we have much more interaction in the future, where we can more extensively share your ideas, maybe publish these kinds of things. And the today's lecture that you have given, we can even put it online on our blog, which we propose to make. Thank you so much, sir. A small submission that I had to make. Thanks.
Thank you so much, Anuj sir. We also have one question, and the question is from Roshan Thakur. As you mentioned, sir, the rules are tilted in favor of the developed countries. Other than coalition, what other methods can the developing countries use to push forward their interests in the international arena?
Should I attempt to respond?
Yes,
Or
sir.
would you
Yes, sir.
like to take a few more questions?
Yes, sir, please.
Okay. Thanks a lot, Professor Anud Vaksha, for your observations. I would be very happy to interact with the students of University School of Law and Legal Studies. And as you say, a couple of hours a month, I would be more than happy to interact with them. And in fact, if there's an interest on a module on trade law and trade policy making, one could even contemplate something along those lines. Short point being that I'll be delighted to interact with your students and provide whatever bit of guidance I'm capable of doing. So I'm happy to do that. Coming to the question of Roshan Thakur. Roshan, the closest illustration which I can give is what happens in our everyday life. There's a comment saying, right? Jiski lathi uski bhains. Unfortunately, the reality at the negotiating table is not very different. Countries that have the political power, economic clout, they have a huge heft at the negotiating table. And as I mentioned, coalition is certainly the most effective way through which developing countries like India can seek to, in some manner, address this asymmetry. Apart from coalitions, one can be better technically prepared to participate in the negotiations. One can use research to propagate one's negotiating approach, but all these require resources, these require time, and most developing countries really are hamstrung in these endeavors. So in a nutshell, really the answer lies in coalition. No developing country, however capable, however economically strong, can hope to achieve success at the negotiating table single-handedly. Once in a while, it does happen. India managed to do it in November 1914, but in November 2014, sorry, but that is really once in a blue moon. That was through indulging in brinkmanship and through what is called issue linkage in international relations. But as I said, it's really very rare. More questions?
Do we have more questions? The attendees can write those questions in the chat box. Yes, sir. Yes, Anuj, sir.
Sir, in our traditional textbook, we used to hear that international law is Eurocentric. As we move to 21st century and forward, do we have indications that Eurocentrism, which now seems to be Europe and American centricism, that is getting diluted or that is getting strengthened by the time? How do we look forward in the future? As a inhabitant of a developing country where the world is more egalitarian politically, economically, or it's more divided between the collision of developed countries and the developing countries? Thank you, sir.
Thank you, Professor Anuj, for your question. You're absolutely correct that the international economic laws, particularly at the GATT and WTO, has been Eurocentric, Although I must mention that the provisions of GATT, some of the key provisions of GATT, for example, MFN and national treatment, these were modeled on the initial free trade agreements of United States. But overall, it is absolutely bang on dot, absolutely realistic and correct to mention that the way the rules have evolved and their contents really is an articulation of Eurocentric approach. My apprehension is that this will only get deepened over time unless developing countries get their act together and join hands. Unfortunately, the developed world has managed to, in a way, create an impression that the interests of developing countries are heterogeneous. There is no commonality in their interests. And through this strategy, developing countries are effectively failing to provide their imprint on how international economic laws evolve, and which really is a matter of concern. So in a nutshell, again, this trend in a Eurocentric approach in international economic laws is likely to continue. Of course, there could be some exceptions here or there, but even to secure those exceptions, India and other developing countries will have to wage a very, very persistent struggle for it. Sorry for this rather pessimistic response.
No, sir, but it is the truth, that the reality that we have to face, and we can make any move forward intelligently if we know where we stand. So we continue to stand at more or entrenched Eurocentric international economic law. Once our future generation, our students know this, they will understand the difficult challenges that we have. And that should be the starting point for us. Yes, sir. Thank you, sir.
Absolutely, absolutely correct, Professor Anuj. Our objective should be that we should be able to successfully challenge at the intellectual level the propositions, the narratives that get created by this Eurocentric approach to international economic laws. And that won't happen overnight. That requires a very careful nurturing. It requires huge dedication, huge commitment, and sacrifices, of course.
So we have another question, probably the last question, by Mr. Mahipal. As of current scenarios of world as importing crude oil from Russia is so-called basic necessities for European Union nations, but on the other hand, violation of sanctions if India or other developing or underdeveloped nation does the same. He asks for your thoughts.
Well, on this issue, India has very, very clearly tried to expose the underlying hypocrisy in the approach of the developed countries. On the one hand, some of the developed countries are so overwhelmingly dependent on energy resources from Russia that they don't mind, rather they would be in a problem if Russia were to close the energy taps on the energy pipelines, as has happened in the recent past. But at the same time, they expect countries like India not to trade with Russia. This certainly is a problematic approach. And this inherent hypocrisy has been called out and should be called out as loudly as possible. Hope that answers your question, Ipal.
Thank you so much, sir. I now request Dr. Zubair Ahmed Khan, sir, to offer a vote of thanks to our dignitaries, guests, and participants. Over to you, sir.
Thank you so much, Nishant. Am I audible?
Yes, sir. Yes, sir. Perfect.
Okay, thank you. A very good evening to all the respected Professor Abhijit Das, sir, Professor Anuj Vaksha, sir, and Professor AP Singh sir and Professor Rakesh Kumar sir, and all the participants present here. I feel honored and privileged to propose my vote of thanks on this special day, particularly as said by our Dean sir and Professor Abhijit sir also. That is our inaugural webinar for our cell, International Economic Law and in International Relations cell also. And on behalf of my organizing committee, I like to convey my deep regards and sincere gratitude to Professor Abhijit sir, who have taken the whole topic of changing paradigms in international commercial law in a very holistic manner. Sir has discussed about how the WTO issues become very significant in the multilateral negotiations, and he also discussed about bilateralism, multilateralism, and how multilateralization may become significant in the contemporary world also. So thank you so much, sir. You have raised many more issues, research questions, and in the near future, we're going to organize a number of events on the unexplored topics of the international economic law. And I'm sure our students will definitely will enjoy and enrich their experience because of the same events which we are going to organize. And I'm also thankful to my student coordinators also, and particularly Nishant, Roshan Thakur, Anu, and Jia, and all other students who have been part of this newly constituted cell. I'd like to give my sincere thanks to our Honorable Vice Chancellor, Professor Mahesh Sharma sir, my Dean, Professor AP Singh sir, Professor Anu sir, and Professor Rakesh sir, and all the faculty colleagues for their continuous support altogether. Thank you so much, sir.
Thank you, and hope to stay in touch with all of you. Thanks once again.
Thank you so much, sir. Thank you so much, sir.
Thank you so much.
I request all the dear students to kindly fill the attendance link for their certification purpose. I think we may stop the recording.